Welcome to AT&T's teleconference service. Please enter your access code, followed by the pound sign. There are 1 participants on the call, including you. You are joining your conference as the host. For a menu of available commands, press *#.
All right, good morning, ladies and gentlemen. The hour of 10 o'clock having arrived, we will call to order the County of Santa Clara's Federal Affairs Advocacy Task Force. We have, as part of our call to order, we'll ask the clerk to please call the roll and establish the presence of the quorum. Here? Here. And we want to welcome also Representative Rocana's office, who has made a timely arrival. Welcome. And that takes us to item number 2, which is public comment. Public comment is that portion of our agenda set aside for comment by members of the public on non-agendized items properly within the jurisdiction of the task force. And the clerk indicates that there are no members of the public who've asked to speak under public comment today. So we will move on to the consent calendar and changes to the task force's agenda, if any. I'm not aware of any. There is a little excitement in the chambers apparently, but there you go. Supervisor Cortese, any suggested changes to the consent calendar, or just shall we, without objection, accept the calendar as an agenda as presented?
As presented.
Thank you very much. That then takes us to verbal reports from the chairperson and the vice chairperson relating to items of interest to the task force. And I have no reports today. Anything from you, Supervisor Cortese, on the federal front?
None today, thank you.
All right, thank you very much. Then we will go to the CEO's verbal report, and looks like Mr. Marquez is sitting in today on that one. So anything you want to share with us at this point, Mr. Marquez?
Sure, I can share with the task force that in a previous meeting we had talked about the grant funds that were being not distributed as they were. I think it came up in yesterday's board meeting as well, or in some other forum that we were in. So good news on that front. There was some, I'm trying to see here on my notes that were provided, but there was some process that occurred with some of our representatives out in Washington, D.C., and they raised the issue with the Trump administration, and as a result, the monies have now been released. They're not released directly to the county, they go directly to the Conservation Corps. But I think that's good news, having our representatives in Washington, D.C. Provide an assistance to us in that front and getting some, I guess it was the Acting Assistant Director of Ecological Services who ended up notifying us that the money will be released. So that's good news to report. Also, just was informed that one other report, the Senate Majority Leader Mitch McConnell announced that he's canceling all but a week of the Senate's traditional August recess. His announcement stated that the Senate would take a break for only the first week of August because of, quote, historic obstruction by Senate Democrats, and will stay in session the rest of the month. His statement indicated that the Senate needs to pass legislation, including appropriations bills, and to make additional progress on the president's nominees. The move, however, has political ramifications as it will help keep vulnerable Democrats off of the campaign trail. So those are some of the latest. And let me ask Danielle, there's one more thing that I haven't had a chance to read. Is this something you'd like me to announce here in this report?
Ms. Christian?
Yes, if you wouldn't mind. It's just some general information about the discharge petition related to immigration that's occurring in the House. And I think it would be of interest to the task force.
Will do. So a coalition of some Republicans and nearly all Democrats has been working to go around House Republican leaders and force a debate on a series of immigration bills against the wishes of majority leaders. The mechanism is called a, quote, discharge petition, which is a means of bringing out a bill out of committee and to the floor for consideration without cooperation of the leadership by, quote, discharging the committee from further consideration of a bill or resolution. The petition needs 218 signatures of House members, regardless of the size of the current House. If the backers of the discharge petition obtain the necessary signatures, the merits and demerits of the discharge petition itself would receive 20 minutes of debate on the floor. However, advocates of the effort aren't discharging a solitary immigration DACA bill to the House floor. They are discharging a framework for the House to consider a sequence of 4 immigration DACA bills. So after debate on the discharge petition, the House will vote up or down on the petition itself. If the House votes in favor of it, members will begin an hour of debate on the framework to accommodate the 4 measures. The measures, in order that they will be considered, are 1, a conservative immigration plan backed by House GOP leaders and authored by Senate Judiciary Committee Chairman Bob Goodlatte, who's a Republican from Virginia. 2, the Democrats' DREAM Act, which is backed by Representative Lucille Roybal Allard, who is a Democrat from California. 3, whatever bill House Speaker Paul Ryan elects to put forward. And 4, a plan supported by Representatives Jeff Denham, a Republican from California, Will Hurd, a Republican from Texas, and Pete Aguilar, a Democrat from California, which bolsters border security and grants legal status to many DACA recipients. So the blueprint under which the House is considering the bills is a little different, and in the end, the House may not end up approving any one of these bills. This background is to update the task force that 213 signatures have been obtained. Republican supporters have said that if they do not like what the Republican leadership is offering by this Thursday, they will be able to put up the last 5 signatures. So unless you have any questions, that would conclude the report from the County Executive's Office.
All right, we'll say thank you very much for that and move on to County Counsel for his report.
So good morning. We have provided our monthly update with the matrix, and we've updated it based on some input and feedback to try to make it clearer. We were asked today to provide a specific report, and I'm going to ask Adriana Benedict, who's Deputy County Counsel, in just a minute or two to talk about some of the recent use of the Congressional Review Act to rescind a CFPB guideline related to auto lending. So she'll talk about that in a moment. But I also just wanted to provide the committee with an update that a decision came out this morning from Philadelphia, and a district court judge ruled 8 U.S.C. 1373 to be unconstitutional, in part based on the recent U.S. Supreme Court case on anti-commandeering. So that's obviously a pretty significant development, and it's the first kind of significant merits decision on the validity of Section 1373. So we'll be reviewing that and, of course, provide further updates.
And for those who are listening and may not, 1373 refers to?
8 U.S.C. 1373 is the federal statute that the Trump administration has been asserting is the imposition of requirements on state and local governments to provide certain information, and this administration has said other types of cooperation with the Department of Homeland Security related to civil immigration enforcement.
Thank you very much. And do I understand we have a report from your office?
We
Welcome.
do.
Please identify yourself just for the record.
Good morning, Adriana Benedict, Deputy County Counsel. The Equal Credit Opportunity Act, or ECOA, prohibits creditors from discriminating based on race, color, religion, national origin, sex, marital status, age, receipt of income from any public assistance program, or the exercise in good faith of a right under the Consumer Credit Protection Act. On March 21st, 2013, the Consumer Financial Protection Bureau, or CFPB, issued Bulletin 2013-02, a non-binding guidance document regarding the CFPB's discretionary enforcement approach to indirect auto lenders' compliance with the fair lending requirements of the ECOA and its implementing regulation, Regulation B. Indirect auto lenders receive information about auto loan applicants from car dealers and determine whether and under what circumstances to offer a buy rate, which is the minimum interest rate at which the lender is willing to purchase a retail installment sales contract executed by the consumer for the auto purchase, which contract the dealer may execute and then sell to the lender. An indirect auto lender's markup and compensation policies may permit a dealer to mark up the interest rate above the buy rate, which may result in a dealer reserve, which is compensation to the dealer based on the difference between the buy rate and the contracted interest rate. According to the CFPB Bulletin, these policies are associated with significant risk of unlawful discrimination due to the scope of discretion permitted and incentives offered. The CFPB Bulletin suggests that indirect auto lenders are creditors under the ECOA and Regulation B if, in the ordinary course of business, they regularly participate in a credit decision, and they may be liable under the ECOA if their markup and compensation policies result in unlawful discrimination or if they were on constructive notice of a dealer's discriminatory conduct. The CFPB Bulletin recommends that indirect auto lenders ensure compliance with the ECOA and Regulation B by reviewing and/or monitoring their policies and their implementation and undertaking compliance programs and corrective actions as necessary. On December 5th, 2017, the Government Accountability Office opined that CFPB Bulletin 2013-02 is a rule for purposes of the Congressional Review Act, because under the Congressional Review Act, a rule includes an agency's statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. And the bulletin is a general statement of policy as defined by the Supreme Court in 1993 in Lincoln v. Vigil. The Government Accountability Office noted prior instances in which agency guidance documents have been determined to be a rule under the Congressional Review Act, and on December 6, 2017, the CFPB Bulletin was printed in the Congressional Record. Under the Congressional Review Act, Congress has 60 legislative days to introduce a special joint resolution of disapproval of a rule submitted to Congress, and Congress has taken the view that the publication in the Congressional Record triggers the 60-day window. If Congress disapproves the rule pursuant to a joint resolution of disapproval, the rule is treated as if it had never taken effect, and an agency is prohibited from issuing a rule in substantially the same form absent subsequent authorizing legislation. On May 8, 2018, Congress passed Senate Joint Resolution 57, providing for congressional disapproval under CRA of CFPB Bulletin 23-02. On May 21, 2018, President Trump signed the resolution enacting it into law. It is unclear what the impact of the Congressional Review Act repeal of the CFPB Bulletin will be. Some argue that the Government Accountability Office's determination does not have the force of law. The CFPB Bulletin is not actually a rule, and therefore the Congressional Review Act repeal has no effect. Even if the guidance is a rule and the repeal is effective, there is significant disagreement about what it accomplishes, because the CFPB Bulletin is non-binding on courts, federal and state prosecutors, and even the CFPB itself. The Congressional Review Act repeal certainly does not prohibit any enforcement actions consistent with the CFPB Bulletin and otherwise consistent with law. Further, it's unclear that anyone would have standing to challenge the issuance of a future guidance that was substantially the same as the CFPB Bulletin because of its non-binding nature. We are not aware of any lawsuits challenging the CRA repeal of the CFPB Bulletin, but the CFPB's constitutionality is currently being litigated in the 5th and 9th Circuits and has already been litigated in the DC Circuit. We will continue to monitor the issue.
Well, I'm exhausted just listening. Supervisor Cortese, questions?
Yeah, I just out of curiosity more than anything, I guess it's the answer to some personal trivia question, but I used to actually be in the business of financing conditional sales contracts at one time as a young man for many years, actually. What after all of the years that the practice that you described has been going on, dealer reserve, indirect lenders, sort of this market back and forth of contracts, do we know what the underlying motivation or initiative was of what we're now calling the new rule? I mean, it just seems like that comes out of nowhere after 40 or 50 years. By the way, I understand that there's a sort of an assertion that that this could be leading to bias or some sort of indirect version of redlining, it sounds like, or maybe if not redlining, just taking advantage of people with higher interest rates, irrespective of their credit score. I'm not sure that reality actually exists, but was there evidence of that, or what triggered all this is what I'm really asking, or do we know?
When the CFPB issued its bulletin, it indicated that over the course of its enforcement efforts, it had identified a pattern of practices that were likely to lead to discrimination, and that was the impetus for issuing the bulletin.
But
It did not go into detail about specific instances, although I believe that the CFPB website has public consumer complaints that can be reviewed.
I see. Okay, thank you.
You're welcome. Thank you so much.
And just before we let you slip away, so next steps from our standpoint are what? Ms. Benedict, hang on just a moment, please.
We'll monitor and see kind of what happens from here, but it appears that there's, because this was kind of non-binding internal guidance to this Bureau, which is really frankly facing more existential threats. In essence, the Bureau itself is being gutted. The new, acting director of the Bureau has made clear that he doesn't want it to exist. In light of kind of that context, it's not clear. The Bureau's entire enforcement program is basically withering away. So the existence or not of kind of the non-binding guidance to enforcement arms of the Bureau to pursue this is kind of in that context, not really the primary, I think, issue right now, I would say.
All right. Thank you very much. Thank you again, Ms. Benedict. Anything else, Mr. Williams? You know you're going to get a question from me on net neutrality, so you might as well just go there. So.
Sure. Well, the net neutrality, we're in the early stages of coordinating with all of the various entities in the consolidated case on briefing. I think the only real update is actually not on the litigation front, but really on the legislative front, which is that a number of states have been continuing to pursue state legislation to try to embody net neutrality principles in state law through various mechanisms. I think the most interesting of those mechanisms has been to utilize state purchasing authority to basically say the state is going to only contract with internet service providers that commit to similar net neutrality principles as were in existence under the rule that was rescinded, and basically say otherwise the state's not going to itself acquire services. Obviously states are pretty significant buyers of internet access and service, and so for several states to together get on the same page with that could actually have a real market impact. And a number of states have tried to coordinate around that. So that's, I think, probably the most significant current update, but the litigation is moving, but it's moving as much litigation does, which is at a slow and steady pace.
All right, thank you. Supervisor Cortese, questions?
No, thank you.
All right, then we'll say thank you for that report, and we will move on to, and I do know that we have folks who are on the line, even though I've not yet asked them to all introduce themselves. I'm just going to ask them to introduce themselves as their items come up. That takes us to item number 7, which is to receive a verbal report from the administration relating to the fiscal year 2018-2019 federal budget and appropriations process and proposed presidential rescission package for the 2017-18 adopted budget. So who's going to lead on this one?
Danielle Christian, Legislative Manager. We have one and possibly two representatives from Prime Policy Group on the line, and I'm going to ask Marty Paoni to provide a report on this, and perhaps Aaron as well.
Yeah, Aaron is here also.
I'm here. Hi, this is Aaron Dorton, and I'm here also with Marty, as you just heard, and we'll go ahead and sort of split this report as we go along.
Thank you.
So as you all may or may not know, the appropriations process is in full swing. Yesterday there were several subcommittee markups. The Senate marked up the Transportation HUD bill, that's the Housing and Urban Development bill, and they also marked up the Military Construction Veterans Affairs bill. Today, the full House is marking up full House committee is marking up the Interior and Environment bill. Tomorrow, there's several being marked up in the Senate full committee, Transportation HUD and Military Construction VA, and the House Defense Subcommittee subcommittee is going to mark up their bill. And then in the bigger news is that they're going to bring the first of several minibuses, which is a group of 3 bills, to the House floor tomorrow: Energy and Water, Ledge Branch, and Military Construction VA. Senator Shelby and Representative Frelinghuysen, chairs of the House and Senate Appropriations Committees, are in general agreement that they plan to have all the appropriations bills reported out of committee by the end of June in hopes of then bundling them into packages for floor action at some point this summer. So whereas the 2-year balanced budget agreement gave increases to both domestic and defense spending, as we all know, election year noise will undoubtedly get in the way of productivity. Democrats are already rumbling about unusually low levels within the domestic programs and what they call poison pill riders. And recently, we've seen with the Farm Bill, which was held up on the right by immigration issues and on the left because of SNAP funding, we don't really know what could happen. And since we put this together yesterday, we actually found out that first 3-bill minibus is getting some pushback now by Leader Pelosi. She sent a letter, as I understand it, to the caucus yesterday to discourage her members from voting for it, basically because it is sort of that other bills have not been fully negotiated, and she's afraid that they're going to have much lower funding levels on certain healthcare and education type programs. So although it remains to be seen what can happen, because it's pretty hard to have people vote against the Veterans Affairs, the Veterans bills, and military construction bills. So that's going to be a tough one. We'll see how that plays out. That's sort of breaking news today. With respect to the rescission package, the latest rumor is that the White House is resubmitting their rescission package based upon the whip count they had in the House. Conventional wisdom is that it will not pass the Senate, even if the House passes it. But you never know on a simple majority vote how that could play out. So the new rescission amount is $553 million less than the original. Broken down, that's $134 million for transportation, which it turns out that the GAO instructed the administration, that was the Government Accounting Office, instructed the administration that the money was mandatory, and therefore needed 60 votes to rescind. 157 for Hurricane Sandy related relief was put back on the table. 252 for Ebola, with Ebola having a sort of a resurgence out there, they decided to put that back in. And then $10 million for water quality funds at the EPA. So the question is, how does this fit with the current appropriations plan? Senators Shelby and Leahy, who are the chair and ranking in the Senate on the Appropriations Committee, are in general agreement that from a structural standpoint, rescissions are under their purview. They're essentially a tool that appropriators would use to move the money around. And so appropriators in general don't like to give up that authority. On the other hand, the Senate is working at the committee level to produce realistic appropriations bills. And the administration's rescission package makes it difficult for the Senate Republicans to complete negotiations with their Democratic colleagues on next year's appropriations bills, because those bills could also be subject to an administration rescission request after they've been signed into law. They can't afford to lose any votes. For example, it's tough to ask people to vote to rescind money for CHIP, the Children's Health Care, at any time, but especially in an election year. So by contrast, the House bills are not being written to pass the Senate. For example, one of the cardinals in the House thought his 302B allocation was too high, so he created a new account called something like Future Generations Account, where no money can be spent from it until the budget deficit is reduced to zero, and stuffed hundreds of millions of dollars into it. just on a procedural matter, Senator McConnell is not interested in the rescission package from a standpoint of being an appropriator originally himself. He just does not like the idea. And number two, he wants to be able to negotiate in good faith. He doesn't want to give the Democrats something to use against him, and he does not want his members to have to take a tough vote. So Marty can fill in with color on anything or answer any questions, but that's all we have.
I think Erin's pretty well covered it very well, unless you have questions.
I think the ask I would make, and I may want to engage, this is Supervisor Simidian, may want to engage our county staff here in the room, is if we can connect the dots or make the connection as to how these activities affect the county or are a matter of concern to the county, if at all. And that is, of course, part of the reason for this exercise is to try and make some sense of what relevance does the activity that we read about on a daily basis in Washington have to our own operations. I'm assuming that to the degree that health and social services funding is funded at lower levels for Republican priorities, that's part of the sort of broad concern here. Let me look to Ms. Christian to see if I can get you to help walk us through some of this, or at least point us towards somebody who can. Mr. Marquez, Ms. Christian, anybody?
Well, this is Erin. I could actually just say that just from immediate standpoint, that's basically what Leader Pelosi is driving at.
And that's the reason for her pushback? Excuse the interruption.
Correct. Yes. That's the reason for her pushback. Is the reason for her letter, which I have not seen a copy of. For all intents and purposes, she does not want to give all of her members this vote right now on the other bill, the first minibus, if you will, without negotiating a better deal, in her opinion, on, for example, the labor HHS bill.
Okay. Mr. Marquez, anything? Ms. Christian?
My understanding, if I understood you correctly, Supervisor, is trying to get a sense of how all of these moving parts in Washington, D.C. might affect the county. Certainly we have infrastructure in place where we track and we're looking at it. It's such a fast-moving process. I get emails myself all the time, and you get different information, because it just changes almost by the day. But certainly we are keeping track, and if the task force would like it, we can certainly try to put our latest thoughts on where we are and what impact any of the latest happenings in Washington, D.C. may have on particularly HHS, which is where we have most of our state and federal money, or federal money, that much of it which flows through the state, coming to us. We're happy to provide that kind of information.
Well, let me just go to the folks at Prime and ask the question this way. And again, this is Supervisor Simidian speaking. I think we all breathed a sigh of relief when, in the budget debate some months back, the president expressed some frustration about the fact that, in his view, Democrats had had made too much progress on domestic priorities, and that was the subject of quite a bit of conversation. Is this essentially the follow-on from that, or is this on to a new conversation altogether?
I think basically he was also upset that he didn't get the money for his wall in that package, and he said that he would not sign another bill that included all the appropriations bills, which is why Ryan and McConnell are trying to at least send him some bills. This first tranche would be 3 of them. They're the usual low-hanging fruit, the relatively non-controversial ones: energy, water, ledge branch, and MilCon VA. And they were trying to at least get so that he couldn't say, well, you've done it to me again, because quite frankly, and Pelosi's concerned that even though there was an increase for domestic spending, they haven't seen the actual details as to how the Labor Committee, Labor HHS money is going to be divvied up within the programs. I mean, is going to get more money. They know that, but it may go to priorities that Republicans like versus what she thinks is necessary. Front load, put all the money into NIH, and shortchange education or community projects. So she wants to see how that is going to shake out, and hence her attempt to rein in the Democrats. And we'll see how that works if she's able to, and to try to get a deal on labor age. But meanwhile, you should be aware that whatever deal happens, if there is one, you're really not going to see. Probably labor age will get done as a CR in September, and then they'll have to deal with it in the lame duck. So we may not see the real details of that spending bill until the full year going into next year, until after the election.
Thank you. Let me turn to Supervisor Cortese, see if he has comments or questions at this time. Supervisor?
Only that I would appreciate, some kind of tracking, some sort of top line from, the COO's office or the executive's office. Perhaps it's possible for that to be, I'm not sure if it should be issued after we get these briefings just to be efficient, within a couple days afterwards, or if there should be a separate briefing with the administration before we get here, so that top line's here to help us follow, if there is any tic-tac-toe as to what's going on here, that lands or even threatens our budget. I think that's what we're most interested in. And I understand it's changing quickly, but a lot of things change quickly, and we take snapshots. That's what we do, and try to measure from there. So I don't want to make too much work, given that there's not much certainty. I think that's the bigger problem. Maybe not that it moves so quickly, but that what seems to be what was yesterday's news is kind of a fickle thing right now in D.C. And if you base a lot of analysis on what we've heard today, I understand that could be just out the window day after tomorrow. But I think I want to agree with what concern I think I heard from President Simidian here, is that we need to have a little bit of a top line, or I'm not sure if it's a chart or graph. It seems more like just a set of bullet points as to issue, almost issue, possible impact or potential impact. I think it's just really 2 columns. But I'll leave it to you all to decide whether it's more efficient to do that ahead of these meetings as part of the prep for the meetings, or afterwards, immediately afterwards off agenda. I think the problem with that, of course, is that it's much harder for us to get that out to the public.
We'll follow up. Thank you, Supervisor. We'll follow up both with the County Executive's Office and with our Government Affairs team here, and also with the folks at Prime and in my office. I do think, and this is in part directed at the folks at Prime, as we both of us, members of the board of the task force here, have referenced now. I think it is sometimes hard for us to sift through all of this and sort of pull out the nugget or two that says, look, who knows whether or not this will or won't come to pass, but the reason we care about all of this activity is, and then boom, because I find myself, Supervisor, with just as simple as reading the story in the newspaper saying, sounds like I should be worried, but I'm not really sure if I should be worried, and I'm not really sure what it is I should be worried about. And so I think that's the refinement that we're hoping we can develop a little bit more, understanding that, as Supervisor Cortese suggested, tomorrow that may not be the story, and by next week the world may have changed dramatically given the rate of change here, but I do think that would be helpful. All right. Thank you very much. Anything else under item number 7 on budget and appropriations? If not,
nope.
Thank you. We will go to item number 8, which is to receive the verbal report from the administration relating to federal health policy and budget landscape, including a proposed rule change to Title 10 regulations, compliance with statutory program integrity requirements regarding family planning funds. Who's going to lead off on this, Ms. Christian?
Thank you. Mr. Margolin from the Margolin Group should be on the line.
Thank you. We'll find out.
Yes, I am. I'm on the line.
Okay, go to it.
Okay, good morning. So let me start by observing that congressional action on key health issues of concern.
Mr. Margolin, excuse the interruption. A little more slowly. You think faster than I can process, as I've teased you before. Thank you.
You have made that observation in the past, so I will slow down. So the first observation I would make is that congressional action on key health issues that the county cares about is winding down because we're in, as Prime Policy just suggested, in the height of the election season. The ACA threat that we dealt with over the last year, it isn't 100% gone, in that there are some hardcore opponents of the ACA in the Senate who are still agitating for another run at the ACA, but that's very unlikely. The Senate leadership doesn't want to go down that road. They don't have a vehicle that would allow them to do that that can be very easily created. So that's probably not going to happen. The same applies to major changes in Medicaid, a very difficult issue to raise in the middle of an election campaign, and that threat has also faded. We've also been tracking federal threats to the 340B drug discount program. We're dealing, as the board knows, with a threat to that program at the state level right now in terms of the state budget negotiations. There's been kind of a parallel discussion going in Washington about making it harder for counties like Santa Clara's health system to access the 340B drug discount. And while the Energy and Commerce Committee could take up the issue this summer, and they've had many hearings on it, it now seems less likely that they're going to do major legislation on 340B. You just heard a discussion about the rescission package, and again, the piece of rescission, the effort to take back, to do additional savings, take back federal money, cut federal money through this special mechanism, the piece of that impacts health that's been talked about is the CHIP funding piece, and that is in the package, and it may or may not survive, but even if it were to be implemented in its current form, the CHIP money they're going after is money from a CHIP contingency fund. It's sort of excess surplus money. It still has value to the program because, states, it could be California, when they get in a bind, may need to access that money if their CHIP enrollment goes up, or there may be other circumstances where that CHIP funding in the contingency fund can be used to fund other healthcare programs. But if it was successfully eliminated through rescission, it would not impact the California program, even though you'll read articles about CHIP and the threat to CHIP, because again, it's contingency funding. It's not funding that's their FAR-based program. So that's the legislative front. Where more action has been occurring has been on the administrative front, and CMS continues to promote work requirements. We've talked about that in the past. They're doing that through negotiations state by state. In fact, when the state of Virginia approved just last week their Medicaid expansion, after years and years of trying to get the program expanded, they failed year after year. They finally got it done. As a condition of getting Republican support for the bill in Virginia, they needed to put in work requirements. So work requirements continue to be part of this national debate. And then on the rulemaking side of the equation, CMS has continued to promulgate rules that would have the effect of weakening access to health care. The most recent rule in that regard involves short-term health insurance policies. These are policies that people are supposed to get for a very limited time period, and they do not include the requirements of the ACA in terms of benefit packages and pre-existing condition protections. So they're weaker coverage, but they're also a lot cheaper. The administration is trying to make those policies more readily available for a longer period of time, making them one-year policies, going from 3 months to 1 year. And the effect of that would be to take healthy people who currently would be buying ACA coverage, and by being healthy, help keep the cost of ACA coverage down because they add to the pool a good population with low risk. And if they buy the short-term policies instead, because they're now available at even cheaper cost, the ACA coverage becomes more expensive. That's a shorthand way of expressing that. So there's that kind of activity going on. But the rule that's been recently released that is perhaps the most controversial of the administration's actions in the area of healthcare is the Title X rule. And let me talk for a few minutes about that. Title X is the first and still only federal program directed exclusively at providing grants for family planning services. That's what Title X is about. It's been in existence for many, many decades. It was created during the Nixon administration. The proposed Title X rule that's become so controversial is aimed at limiting the ability of family planning patients receiving services under Title X to be able to access abortion services. It's designed to make that much more difficult. And it also is designed to go after abortion providers such as Planned Parenthood who are in the Title X system. And it's designed, this rule, to force Planned Parenthood providers to leave Title X, to be denied Title X funding because of their relationship to abortion. There's a shorthand, it does other things as well. There's a shorthand term for this rule that you may read about and hear about. It's called the Title X gag rule. And the reason why people refer to it as the gag rule is because there's a provision within it that specifically prohibits physicians and other healthcare providers from discussing the option of abortion with their patients. It's part of that effort to restrict access to abortion services. You're told as a provider, you're sitting down with someone delivering a family planning service, and you can't raise the issue of abortion. You can't talk about abortion. You can't refer for abortion services. So it gags the ability of the provider to engage in that discussion. So it's called the gag rule for short. The battle that we're currently involved in concerning the Title X reg really goes back to this particular fight goes back to the Reagan administration, which made a similar but not identical effort to restrict Title X funding. It ended up being litigated, went into the courts. Finally, the courts sided. By this point, Bush was president in 1992. They finally sided with the Reagan-Bush proposal to limit Title X funding, and it was about to take effect when Bill Clinton became president and rescinded the rule. And it's been a fairly quiet front, this Title X issue, until the Trump administration renewed the fight with this latest proposed rule. So a couple more facts about it, and I'm happy to respond to questions. How does this Title X rule actually impact the ability of Planned Parenthood specifically to participate in the system? I mean, the gag rule part of this, the prohibition on speaking, is a more generic threat to anyone in the system who provides family planning services. It restricts access. But there's a provision of the rule that goes after Planned Parenthood facilities by saying that if you're in the Title X program, you have to create, and you also do abortions as a secondary part of your business, you have to create a totally separate physical space, physical operation, different building, different space to provide those services. And you have to provide those services with separate staff and through a separate financial structure. No connection to the structure that gives Title X funding. So you can see that the burden that would impose upon a Planned Parenthood facility, even though the overwhelming percentage of what Planned Parenthood does is family planning, preventive health care services, a very tiny percentage involves abortion services. By forcing a Planned Parenthood facility to create a totally separate physical structure and financial structure, it creates a burden that far exceeds the dollar value of the grants, and it's designed to push Planned Parenthood in particular out of Title X. The Trump administration defends all this by saying, listen, we can't allow federal funds.
Mr. Margolin, again, I need to ask you to just slow down a little because you've got so much good information, but particularly as you come through on our speaker system here, it can be a little tough when you move that quickly. Thank you.
Got it. No, I appreciate that. So I talked about the separation of staff, separate physical space, creates a burden that is financially untenable for a Planned Parenthood facility. Grant is X number of dollars. The cost of complying will far exceed that. It's impractical. This Title X proposed rule is designed to push Planned Parenthood out of Title X. That's part of the intent. And when the Trump administration is asked to defend this, they say, listen, all we're doing is trying to make sure that federal funds do not pay for abortions. That's our simple intent. That's actually not an accurate representation because existing law already guarantees that federal funds will not pay for abortions. There's something called the Hyde Amendment, and it says essentially that Planned Parenthood can't use these Title X funds or any federal funds for abortion services. They have to provide a segregation of those dollars, and those segregated funds are aggressively audited. So the federal government is assured they don't support abortion services, and that's been the law for decades, and it's worked. So this is not about simply making sure that federal dollars don't pay for abortion. Another less discussed aspect of Title X, it's actually part of an earlier RFP that involving Title X that the administration put out involves the issue of allowing providers into the Title X program, which is a family planning program, allowing providers in who do not believe in contraception and who counsel against abortion. They actually want in this Title X rule to say, okay, you can be a provider who is an abstinence-only provider, and you aren't going to provide contraception, and you're not going to talk about abortion, and you never would. And you can be in Title X, which is a family planning program, and that's okay with us. And they do that by taking the term medically approved contraceptive services away from the definition of what's provided here. The current law requires that that contraceptive services that are being provided and counseled about are based on accepted medical science, and essentially this regulation takes that provision away. So last comment, California, the Title X program is a $300 million program. California receives about 25% of the funding. Services are provided to hundreds of thousands of individuals in California based upon this funding. The proposed rule was issued on June 1. There is a 60-day comment period that will occur at the end of July. The opponents of the rule are using the comment period to aggressively challenge the many, many assumptions under this Title X rule that are questionable, contrary to longstanding federal policy, and maybe even other federal law. So there's a flood of comments being issued by groups that are opposed, and of course there are groups preparing for the possibility of litigation. Litigation was used against the original Reagan-era rule, and there's some level of optimism that litigation could prevail here because of a more recent Supreme Court decision in 2016, the Whole Women's Health versus Hellerstedt decision, which was based upon the effort in Texas, the state of Texas, to do away with Planned Parenthood facilities, in effect, by creating a burden on abortion providers that involved having their physicians have emergency room privileges and doing things that for rural Texas would make it impossible for a Planned Parenthood clinic to operate. And the Supreme Court struck down that law in the Hellerstedt decision by essentially saying it created an unreasonable burden on abortion providers. It was a backdoor way of trying to end abortion services. So because of that 2016 decision, there's some hope that litigation might prevail here. But in the meantime, proposed reg is out there. Opponents are providing public comment. As you can see from my description, there are a number of adverse consequences that will flow from this proposed rule, and the logic and reasoning behind it is definitely subject to challenge. Happy to respond to any questions or comments.
Thank you. Before we go back to you, Mr. Margolin, let me just turn to Mr. Williams. Rulemaking process underway as of beginning of this month, if I heard Mr. Margolin correctly?
Yes, they're undergoing the notice and comment process.
And our role, if any, at this point is?
We have or will be submitting comments in that process.
Okay. And you'll share those with board off agenda?
Yes.
All right, thank you. Mr. Margolin, thank you. Supervisor Cortese, comments or questions? All right. Prime, folks at Prime, I know that was a very comprehensive tour of the landscape, but do you want to chime in with any other thoughts or observations?
No, we're just going to have to keep an eye on this appropriations process as it works its way through. We'll see what happens in the House tomorrow. That'll be an interesting vote.
And that was a great summary, though. That was really helpful.
Thank you. And Mr. Margolin,
the Farm Bill and the SNAP program, food stamps, I don't know if they touched on that, but I presume that's an issue that you're all interested in, the food stamp piece of it. That's what that bill will get another vote on June 22nd in the House. In the Senate committee, while it's controversial over there because they have put a lot of work requirements, it's not in the Senate. So far, they have a bipartisan bill that doesn't have such work requirements, and that Agriculture Committee in the Senate is supposed to meet on June 13th to report that bill out. We'll see how that goes.
thank you. Let me go back, Mr. Margolin, on Title 10. I heard you say that the dollar amount nationally was something on the order of $300 million, yes?
That's correct.
And I thought I heard you say as well that roughly a quarter of that was California funding, as we like to think of it, California funding. Did I hear that as well?
Yes.
And is the national push and shove around this issue about the money or about the principle or about the politics or all of the above? It's not an insignificant amount of money, but it's not that much money taken in total, it seems to me.
Yes, no, that's a good point. This will not be a death blow to Planned Parenthood, or this isn't the equivalent of the earlier effort to defund Planned Parenthood. It's a smaller amount of money, and it will not end family planning services. But it's about, as you suggested, it's about all three of those things. There's symbolism here, there's policy, there's practical impact. I would argue that there's definitely a slippery slope argument here. That if you essentially say, okay, family planning is now redefined as something that doesn't involve contraception, we're taking that off, even though this won't end the use of contraception, you're creating a federal precedent that is highly questionable and that that the opponents would like to challenge from the first moment it's advanced. So again, the amount of money by itself is not going to be a devastating blow to these services, but the principles and criteria and the logic being advanced here, if allowed to if sustained and allowed to become part of national policy, could be over time very, very damaging.
All right, thank you. Then, Supervisor Cortese, if you're ready, we can move on to item number 9, which is to receive a report from the administration relating to the House Resolution 253, the Family First Prevention Services Act of 2017.
Yes, Chairperson Median, and I am probably going to have to get up just before the end of this to go outside because we have a ceremonial at 11 o'clock on the plaza that I happen to be emceeing. So apologize for that, but
no worries, understood. All right, who's going to present on this?
Okay. I'm going to present, and I have Frank Mata, project manager from Social Services Agency, who's going to be able to address any questions and provide a little bit more detail on this item.
Good, and I'm going to defer to Supervisor Cortese so that if he's got comments or questions early on before he steps away, he has a chance to do that. So go to it.
Sure. So very briefly, as outlined in the report in your package, the Family First Prevention Services Act was signed into law as part of the Bipartisan Budget Act on February 9th of 2018. It reforms the federal child welfare financing streams to provide services to families who are at risk of entering the child welfare system. This is quite a significant shift, as in the past, the federal government would only reimburse states for child welfare services that were delivered after the children were removed from their homes. It's a little hard to say. Under the Act, states will have the option to use Title IV-E funds for prevention services that would allow candidates for foster care to stay with their parents or relatives. States would be reimbursed for up to 12 months for expenses related to mental health services, substance abuse treatment, and in-home parenting skills training. A written trauma-informed prevention plan must be created, and services need to be evidence-based. The Act also incentivizes states to reduce placement of children in congregate care and places a new emphasis on family foster homes. Reimbursement for group homes will only be available for up to 2 weeks unless the child is in a qualified residential treatment program, a setting that specializes in prenatal or parenting support, or supervised independent living for youth over 18. A qualified residential treatment program must include a trauma-informed model designed to meet the emotional and behavioral needs of children as identified by an assessment within 30 days of a child's placement. And placements would generally be limited to 12 months. The County Welfare Directors Association, CWDA, has identified some concerns and issues related to provisions of the Act that will take effect on October 1st, 2018, and is working with its members as well as the California Department of Social Services to resolve those or identify needed statutory changes. Additionally, CWA and the Department of Social Services, the State Department of Social Services, is working with other partners to engage with the federal administration to provide input to the rulemaking process, because there is an opportunity as far as defining evidence-based and trauma-informed services. It's also encouraging flexibility for states and encouraging county or sub-state flexibility where it makes sense for it to be provided. In general, the goal of the Act is consistent with the state's goals and its efforts, as well as local efforts. But the legislation is rather prescriptive, very detailed in how things must be done with some timelines and constraints, and much is still yet to be determined as things move forward. And with that, I'm happy to answer questions, and then Frank's also happy to get a little bit more into the detail if you'd like.
Supervisor Cortese?
It's probably more of a comment than a question, unless you have thoughts, progress report on it. But my recollection is, as the last time we discussed this was in committee, the Children's Senior Family Committee here of the Board of Supervisors was some time ago, but there was some excitement about the notion that we haven't been able to use these kinds of dollars in the past for the very large homeless population of children that we have in the county, because they typically don't meet the ordinary state definition for child abuse. Social worker talks to them and says, how are your parents treating you? Just fine. It's just that we're all living in the back of the car, right? Which makes it difficult for us to get dollars to them, at least state dollars, non-general fund dollars. And I know there's a lot of excitement in the past about now that, this definition is really starting, focusing the availability of these dollars on prevention services, that, perhaps that's a category demographic that we can focus in on, with the notion that, if you're living in the back seat of the car with your parents, and perhaps there are some general issues, familial issues, substance abuse, obviously parenting issues or challenges. You're on the cusp of mental health issues, generally with children experiencing that kind of situation. Just drawing from the staff report itself here. So I'm hopeful that we can, continue to work to try to make ourselves eligible, especially as we continue to, we got the reports yesterday, the Board of Supervisors meetings about, we're moving along pretty well in terms of the bricks and mortar side of permanent supportive housing. We're trying our best on transitional housing, but the challenge eventually will be, services, the safety net services are going to be provided for those individuals once they're housed. And I think 25% of the population is under 25, and I think it's about 12.5% in our cost study that are under 18. So there's a pretty significant piece there that maybe eligible for this kind of funding. That's what I'm getting at. Besides the monetary side, obviously the humanitarian side of being able to get services to those folks. So just asking that be focused on at the appropriate time, sometime between now and October, to let us know if that's a valid theory or not. Thank you.
Thank you. And I understand you have to step away. Let me just follow up a little bit with a question. Ms. Christian and/or, it strikes me that a lot of this is about sort of simply the flexibility we need to do our work when there's federal direction that's, going to impact 3,000 very different counties around the country. So could we go back to, are there specific programs or services we're worried about being able to provide the way we feel we should be providing them for the clients that we serve here in Santa Clara County?
Yeah, yes, Supervisor, I'm Frank Mata. I'm project manager with the Social Services Agency, and I've been looking at this. One of the concerns, and it's a statewide concern, is that we as a state have been participating in the 4E waiver, which has actually allowed California to wade into the area of prevention services, having counties pilot different kinds of strategies and services that we've been considering, either diversion or prevention, or along those lines. At this point in it, in terms of the evidence-based practices, about half of those practices that we have piloted throughout the state meet an evidence-based criteria. It doesn't mean the other half don't. They may have not been evaluated yet, or we just not know. So one of the major concerns is, as it would impact the state as a whole, does this reset the criteria for what we could consider prevention, or do we have to go back and redefine it, reprogram our prevention efforts that we've been working on for now 6, 7, 8, 9 years? So that is a concern, and one of the major concerns of not only CWDA but several counties, including Alameda and Los Angeles, which started this 5 years before all the other waiver counties had done.
Okay. Thoughts from the team about where advocacy efforts might be most important and/or have the greatest opportunity for impact?
Yeah, we believe, Danielle and I have talked about this, we believe we really need to direct that toward the rulemaking and in the comment period at the federal level, to make sure that that those evidence-based practices do include the promising practices that are evidence-based but may not have yet an established long-term trajectory, to make sure that we include those in the inventory of programs and interventions that the feds will allow us to.
And is this advocacy that we do as an individual county through Prime and/or others, or are we doing it through NACO or through some other organization that's specific to the welfare work that we do, as you referenced, Ms. Christian? I'm just trying to,
Sure.
trying to, again, to connect the dots, saying, all right, we know what we're concerned about. We know we'd like to tell somebody what our concerns are. We know we'd like to ask relief, and I'm trying to figure out who should do the asking and where they should do it.
Yes, so the County Welfare Directors Association, CWDA, has a coalition of partners, including the County of Los Angeles, which is significant in size, as well as the number of children that it serves, and is also working with the California Department of Social Services. And what Mr. Mott and I have discussed is once the coalition starts forming its plan and putting its message together, being a part of that effort, and joining on to coalition letters, but then also taking that same information and providing separate communication to the members of our delegation, so it's aware of concerns that are throughout California that we share, and to the degree that we can provide some specific examples, that are local impacts and county-wide, specific to Santa Clara County, include that in the correspondence that we share with our coalition. As far as submitting comments, that's something we could do in partnership with the coalition, or something else that we could do on our own.
And let me just offer an observation or a preliminary understanding, and please feel free to correct me if I've got it either wrong or incorrect. I want to make sure I'm not missing the big picture here with all the details. It sounds to me like we're not so much, in some of the instances where we've gone back and forth and asked for help from you or county executive's office more broadly, or from the county council or folks at Prime, it's because we have a fundamentally different point of view, philosophically, ideologically, values-driven, whatever, about the direction the federal government has taken in some way, shape, or form. In this instance, it sounds more like our concerns are primarily practical concerns about, and less about sort of deeply felt differences of opinion on ideological or even values-driven notions, that it's just about, yeah, okay, but how do we actually make this work in the real world given the circumstances we're up against here in our county? Am I getting close to the nub of this?
Yes, you are.
Oh, okay. Because as I say, this is sort of a different take on some of these other issues where we just say, no, that's not the direction we want to go. And in this case, it's, well, that might be a direction we could go, but we need to figure out how to make that work for everybody, including ourselves. Okay.
Yeah.
Just as a comment, the previous version of this that died in the Senate in October, there was a forerunner of this. That would have been the one that ideologically we had major concerns about, but it had died. This one has been toned back significantly.
Got it. All right. I have no other comments or questions. Anything from either the staff here at the dais or from folks on the line? All right. Then if not, we have already acted on our consent calendar, which was to approve the minutes of May the 2nd and to approve the cancellation of the August 1st, 2018 task force meeting. That means that we will adjourn to the next regular meeting on Wednesday, September the 5th, 2018. And before we step away for what will be a couple of months, we'll say thank you to the team here in the County Executive's Office, County Council, Clerk of the Board, folks at Prime, Mr. Margolin, and of course, Ms. Narayan from the Congressman Rokana's office. Without objection, we are adjourned. Thank you all very much. Oh, and Mr. Williams, do appreciate the minor changes in the reportage of the County Council's work. It is making it easier, at least for me, to track who's doing what with respect to which issues. Much appreciated.